Hey class, today we're going to go over some of the basics of criminal matters, uh, the practical nature of bringing a criminal case uh, to uh, to court and some of the steps along the way. We're going to specifically talk about criminal procedure later in the class, later in the semester, but I wanted to give you an overview since we've been talking so much about civil cases. I want to give you an overview of how a criminal case would proceed through the system. Again, recognizing that we're going to be talking more about criminal procedure specifically later in the semester. Now, there's fairly significant differences between criminal and civil cases. A criminal case, fundamentally, is an alleged violation of the laws of society, the rules of society, a rule that society has deemed so important that they've attached some sort of limitation or some limitation of the violator's liberty or freedom as punishment for the violation. The state, therefore, is a party to a criminal action against the person accused of the crime, the defendant. So you'll see in a caption of a criminal case, people versus defendant, or the people of the state of Illinois, or the state of Illinois versus the defendant, or U.S. versus defendant. And the whole idea here is that because these are rules of society as a whole, it's not an individual plaintiff that's been wronged. It's the state who is alleging a violation of a statute. Thus, they are a party to a criminal matter. Now, consider what's at stake in a criminal case. It's not money. It's not some sort of restriction to say, hey, you can't go here for, within 100 feet of that person under an order of protection. It's somebody's freedom. It's liberty that's at stake. And if somebody's found guilty in a criminal matter, then they potentially lose their freedom. Now, in a state like the United States, a country like the United States that's founded upon principles of freedom and liberty and maximizing freedom and liberty, this is a really big deal. Thus, the burden of proof to prove a criminal case is much higher than that in a civil case. As you can see over here, this chart that shows the levels of proof. They're basically like a staircase. And we're going to refer to this a bunch of times in class because this is a fundamental idea that there are increasing levels of proof required in different matters based on the severity or importance of the issue. So you can see that reasonable suspicion, a hunch, is a lower burden of proof, lower proof than probable cause. Probable cause, which is sufficient to establish an arrest under the Constitution, is less than preponderance of the evidence, which is what you need to prove a civil case, which is much less than reasonable doubt, beyond a reasonable doubt, which is the finding that you need in a criminal case to establish that somebody is guilty. Again, consider what's at stake when answering the question, why? Okay. And again, outcomes of a criminal matter are different than those in a civil case. In a civil case, the losing side, the defendant, let's say, loses the case, they'll have to pay the plaintiff some amount of money, or they'll be restricted if it's a suit in equity. Their ability to do something will be restricted. You can't build a house there because it's been determined to be improperly zoned or whatever. In a criminal case, we're talking about the liberty of the defendant. If they're found guilty, they go to jail or they go to prison, or they could conceivably lose their life, the ultimate sanction. So this is a much different animal than civil cases. You commence a criminal action by a finding of probable cause. Okay. Now, this is all dictated by the U.S. Constitution and the Fourth Amendment. I have a link here to the Fourth Amendment that I encourage you to check out on the Google Classroom version of this presentation. We'll read through it in class. We'll spend a fair amount of time talking about the Fourth Amendment in class because it's fundamental to all of our individual rights. The state has a lot of power, okay, and the founders recognized this, and relative to the individual, the state could conceivably overstep its power. So they put together a Bill of Rights to restrict the powers of the state. Okay, these are affirmative rights that the people had that restrict the power of the government. The Fourth Amendment is one of those. They don't allow for the state to pick people up willy-nilly off the street. They require the police to establish probable cause that somebody violated one of these rules of society, a criminal law, in a number of ways. For example, if the police observe criminal action, then they can stop that person interfering with their liberty and arrest them if the violation of the state's rules, the state's laws, dictate. So if you're speeding in your car while you're driving down Milwaukee Avenue, and the police pull you over, they're pulling you over because they have probable cause that you violated a law of society, the speed limit. Now, a violation of the speed limit doesn't dictate a punishment equal to going to jail. It's advising that your rights to drive may be restricted depending upon your past violations. You'll probably have to pay a fine, that kind of thing. But the police can observe criminal action or alleged criminal action, and if they observe it, that can establish probable cause. It would then be up to a court to determine whether or not one is guilty of that alleged violation. But the police can arrest you based on probable cause. Let's say the police are interviewing somebody, they're having a conversation with somebody and say, oh yeah, I shot that person. Well, that's a statement sufficient to establish in the police's mind probable cause, and then that interview, that conversation, can turn into an interrogation where the person is now under arrest, and that's another way that somebody can get tagged. An arrest warrant can be issued by a judge. This is where the police are conducting an investigation, and they believe they've established sufficient evidence to establish probable cause against a person sufficient to arrest them. And they would go file paperwork with the court and then plead out, remember pleadings, plead out a arrest warrant. They'd almost certainly also plead out a search warrant at the same time so that the police can not only search the premises of, let's say, the house that the person lives in that's being arrested, but also to search their house to find incriminating evidence and then also arrest the persons, two different documents. Another way you could have probable cause established against you is through a grand jury indictment. Now, you remember we talked about petite juries in the civil trial process. Same idea exists in a criminal case. Well, a grand jury, a much larger jury, grand, can be instituted as well. The feds, the national government, use anywhere from 16 to 23 people on a grand jury. Under federal law, you need at least 12 people agreeing to issue an indictment. If you issue an indictment, that indictment will serve as the establishment of probable cause. Now, you only hear evidence from the state because the defendant isn't present. They don't necessarily know they're being indicted, so they can't defend themselves. So the grand jury comes together, they only hear evidence from the state, and the state basically presents the reasons why they think they have probable cause to arrest somebody or to issue an indictment to let somebody know you've been charged with a crime. There's a very famous saying that a good prosecutor can indict a ham sandwich. Because if nobody's presenting evidence against you and nobody's fighting your case and you're an attorney, you should be able to prove your case before a grand jury. Now, again, I remind you, we will deal with criminal procedure in a subsequent unit. We have an entire unit dedicated to criminal matters. I just wanted to introduce the criminal matters and the outcomes and all this kind of thing to you right now up front in the beginning of the class so that you can see there's a contrast between civil and criminal matters. Now, what are the outcomes of a criminal trial? Well, you could have a not guilty. You can be acquitted, which means you go free. There was insufficient evidence to establish guilt beyond a reasonable doubt, and thus you walk. There could be a dismissal of the charges with or without prejudice. What that means is that the state's case has some defect or a witness doesn't show up against you, and so the case gets dismissed because there's insufficient evidence to prove your guilt. Now, with or without prejudice means that the state may refile the case to bring it up against you in the future, or with prejudice, it's done. That case is done and you can't bring it back. The state can't bring it back again. You can plea bargain a case. You can plead to a lesser charge. Basically, okay, well, I don't, the state would offer a deal to a defendant saying, basically, look, it's going to be a real tough, it's going to be tough for us to prove that we've got you for, reckless driving because there were no witnesses, but we do have enough circumstantial evidence to get you on negligence. Recklessness being a higher level of culpability than negligence, you might plead out to negligent driving, which would be a lesser punishment, let's say. I'm kind of making those examples up on the fly, but you get the idea. You're pleading out to a lesser charge, accepting the certitude of punishment at a lesser level than the chance that you could get punished at a much higher level. There could be a guilty verdict. Okay, in a guilty verdict, you might go to jail. This is kind of a short-term incarceration, usually at the county or state level. Or you might go to prison. Prison is a longer-term incarceration. Prisons are usually at the state or federal level. There's not really a rule of thumb. Some people put it at 6 months or less, you go to jail. More than 6 months, more than a year, you're going to prison. Might be a felony, which is punishable by a year or more in jail. That might be the split. Depends upon jurisdiction and depends upon the place you're in. But regardless, a guilty verdict would result in the loss of some level of liberty. Now, it could also a guilty verdict could also result in probation, where the court says, okay, we found you guilty, but you're a first-time offender. This is the first time you've ever been in court accused of a crime. Rather than throw you in prison, we're going to establish probation. So you might have to meet with a probation officer to make sure that you're staying clean or that you're on the straight and narrow, or it might be unsupervised probation. If the trial is a non-violent, non-particularly serious crime, you might go in and get probation on a driving charge, for example. And so as long as you stay, ticket-free for 90 days, you're fine. Finally, there's non-traditional incarceration, ankle monitors, where the state monitors your location by way of an ankle monitor, GPS positioned in the device at all times, and you've got to check in with the state, but otherwise you're free to work. So, you say from 9 to 5, I'll be at work, and then by 5:30, I'll be home, and that's where I have to stay, and I'll have this designated time to shop and all this kind of thing. And then you're checking in on probation. There's lots of different ways that a criminal case can work out. These 7 are the primary means. Okay, we'll talk more about this in class tomorrow. I hope you guys have a wonderful rest of the day. Take care.